we have an obligation. Regardless, we have an obligation to turn these things over. As many of you know, I was an attorney from 1987 to 2017 in Philadelphia, where I had a very heavy practice in criminal defense and also in civil rights, often civil rights cases involving police. And what I saw over those decades was a continuation of prior decades. It was a system in which both the prosecutor's office and the Philadelphia Police Department went out of their way to circle the wagons and prevent the disclosure of information, even highly relevant information, to the defense. This was in many, many instances a direct violation of the US Constitution. Things did get a little better in 2018 after we came into office. This would have been when Richard Ross was the police commissioner. But frankly, after nearly 4 years of efforts, they have not gotten to a level of constitutional adequacy. The Philadelphia District Attorney's Office is not receiving the information that we must receive under the law in order to be able to make sure that the process is fair and there is compliance with the Constitution. We are living at a time when we see one exoneration after another. They are over and over based upon prosecutors and/or police not turning over information that was necessary for the defense to receive. And in some instances, there have been very, very tragic results, innocent people sitting in jail for decades as a direct consequence of not turning over necessary information. That is nothing that we should ever want to repeat. That is nothing that I want to have anything to do with. We want to make sure that when there are trials in the city and county of Philadelphia, they are done fairly, they are done consistent with the law. And that means that we will need information that at this time, the Philadelphia Police Department is not providing. In a moment, I'm going to turn this over to Patricia Cummings for the specifics. I can tell you that, the bad news is that after nearly 4 years of trying, we're still not there. The good news is that it's our belief that by putting this matter in front of a judge, we will get justice one of two ways. We will either get it because our new police commissioner, Commissioner Outlaw, with whom I have spoken, and I've spoken recently, with whom I've had a constructive conversation, will work with us between now and the time of the hearing to resolve these issues once and for all in a way that satisfies the Constitution, or we will get it by going into a court of law where a judge will make clear what is required of our law enforcement partners, more specifically the PPD, in terms of providing information to us. Either way, we need to get at justice. Time is passing. And it is one thing if we fail in our obligation to be careful and make sure the defense gets information to which they are entitled. It's another thing if we fail because we're not given what we need. If we fail because we have no choice but to fail, because the PPD is not giving us what they need to give us, what the Constitution requires so that we can comply with our duties. And that is just unacceptable. We have to meet our duties, they do as well. And we're very hopeful, based on my constructive conversations with the police commissioner, and by that I mean Commissioner Outlaw, that we will have a path forward before that hearing. Let me get real nuts and bolts about this so you have an idea. And then once again, I'll let Patricia Cummings get even more nutsy boltsy about it. What are we talking about? So we're talking about a situation, for example, I'll just pick one, where you have a police officer who has been found by the police department itself to have lied on official investigations, submitted phony paperwork. In other words, done things that show deceit. That is the kind of information that without question has to be turned over to the defense in a criminal trial if that officer is to be a significant witness. It may or may not come in as evidence in the trial, but it has to be turned over in order to make sure that the process is fair. When we find ourselves in a situation where the police know exactly what's going on because they have all the paperwork of their investigation, which shows that there has been actual deceit in the conduct of a police officer, and they send it to us having taken a black marker and blackened out basically every line. So we don't have any idea what it is this officer may have done wrong, or what it is that the Philadelphia Police Department gathered by way of investigation when we get papers that are basically page after page of redactions done with some sort of a digital or actual black marker. That's not good enough. And that is what's at stake here, because When that happens, we are left in a position where we cannot know what was in those papers. We cannot make the decisions that only lawyers can make, and we are lawyers. Philadelphia Police Department is not a department of lawyers. We cannot make the lawyerly decision to comply with the Constitution, as is my sworn oath, because we don't know what is underneath those redactions. That's just one example of many different types. And honestly, some of the things contained in this motion are pretty amazing. But at this point, it is my pleasure to introduce to you Patricia Cummings, someone who most likely is not a stranger to you because of her distinguished career in this office and elsewhere in relation to conviction integrity, the careful and meticulous review of cases that have gone wrong in the past and many that have gone right. And obviously, she has set something of a national standard for how you conduct a conviction integrity unit and try to right the wrongs of the past. We are here to make sure we don't repeat the wrongs of the past. Patricia?
Thanks, Larry. What I'm going to do is I'm going to build on some of the statements that Larry has made, and then I think, using Larry's words, get a little more nutsy and boltsy than he was in terms of the mechanics of the motion. So Larry is absolutely right when he talks about, as prosecutors, we have a constitutional obligation to turn over certain types of information. What I want to do is I want to pause a little bit and give you a little bit more detail in terms of what that constitutional obligation is and the kinds of information we have to disclose. Most people are familiar when we talk about our Brady obligations because Brady has been talked about so often in the press, and Brady tells us that when, as prosecutors, we have anything that's favorable to the defendant in a criminal case, we've got an obligation to disclose it. Another area of law that came after Brady was decided was a Supreme Court case that said favorable information not only means information that could be exculpatory, in other words, prove the defendant maybe didn't commit the crime, but it also is what we call impeaching information. And impeaching information is very simple, and I think Larry did a good job of telling you what it is, and that is, it is any kind of information that could affect the credibility of a witness. So what we're talking about today is this latter category, and what we are trying to do is, quite frankly, what most prosecutors' offices are trying to do across our nation right now. And that is make sure that prosecutors are collecting any information that could affect the credibility of a police officer, compiling it in such a way that it systematically can be reviewed by prosecutors who make decisions about the cases we prosecute on a daily basis, but also make sure that we're turning it over to the defense as we're constitutionally obligated to do. So Larry gave you an example of probably the most egregious type of behavior a police officer would engage in that could affect his credibility, and that is something that says that the officer lied or was deceitful in terms of their work on an investigation in a criminal case. But some other categories that I think are worth talking about are, you also have credibility issues if, for example, you've got an officer who has engaged in the improper use of excessive force. That is something that could be relevant to a particular case that we're prosecuting. Another category that we've heard a lot about in the news is when officers show themselves to be racially biased. Probably one of the incidents that occurred in the recent past that most people are going to be familiar with was the Plain View Project, where essentially folks had been looking at what are police officers doing on their social media, and what they found really in a lot of ways was quite frightening, because a lot of officers across the country were posting things that were demonstrating that they had a racial bias against classes of people. So that is, generally speaking, the kind of information that we need to know about. We need to know about it, as I said, because not only could it affect our decisions in terms of whether or not we should be prosecuting a case, but we certainly need to know about it because we've got an obligation to turn it over to the defense. Larry also said, and this is so important for everybody to understand, we take our disclosure obligations seriously, but disclosing something doesn't mean we are always in the position of saying that that information could be used in the courtroom against the police officer when the police officer is testifying. Those are two separate issues. Sometimes they go hand in hand, but a lot of times as prosecutors, what we will do is we'll say, yes, we got the information. Yes, we turned it over to the defense, but you know what? It shouldn't be allowed in the courtroom to be used against the officer such that it could affect the outcome of a case. Those are all things we have to do. And what we have been trying to do as prosecutors since Larry was elected is we have been trying to adopt policies and procedures that allow us to have confidence that we are getting the information, we're reviewing it, and we're doing with it as we are constitutionally required. Now, historically, I think a lot of people in Philadelphia know that prior administrations didn't really have a policy in place to make sure all of these things are done. It's really quite shocking when you understand that, especially because what we have seen is prior to Larry getting elected, the police department would freely give that information to the prosecutors. But best we can tell, the prosecutors would get that information and then really wouldn't do much with it. Certainly, they didn't do a lot to determine whether or not the case involving the officer should be prosecuted at the outset. And certainly, they weren't turning it over to the defense most of the time. Instead, the historical practice was this office sometimes would tell the defense, look, if you want information about an officer's credibility, you need to go out and try to get it on your own. And the effect of that was defense attorneys, and not all of them, but some defense attorneys would actually issue subpoenas to the police department to get the information. So that's how it worked. And it wasn't right for so many reasons. So flash forward to the last 3.5 years where we have been saying, we're going to do this right. And every time we said we wanted to do it right, we made every effort to make sure that we had a seat at the table for the police department to collaborate with us in the system. And at the beginning, it was encouraging. It seemed like the police department was going to comply. However, just a couple of months into the endeavor, that ended up not being the case. Instead, what we were faced with was the police department unilaterally making decisions as to what they believed we were entitled to have and in what form we could get it. And so I'm going to turn a little bit to what Larry was talking about when I say the form. The police department would give us sometimes a conclusion of an investigation, and then they would take that conclusion and they would heavily excise or redact out information that they thought we as prosecutors weren't entitled to have. Since the time they started doing that, which has been at least 3 years, we have consistently said to the police department, don't do that. Let's talk about how we can make sure we get the information so that we are making good decisions, not only about how we prosecute our cases and what we disclose, but we also want to make good decisions about when it's right to put a police officer in the database that we've created. What I mean by that last point is there are times that the police department gives us such little information that had they given us the entire investigative file, we might conclude that the officer did not engage in misconduct that affects their credibility. So we might not even put them in the database. So effectively, what the police department is doing by making these unilateral legal decisions when they're not lawyers who are qualified to make those decisions is they are putting the prosecution in a jam. They are absolutely depriving the defense of their constitutional right to rely on us to disclose the information. And sometimes they're even harming their own officers based on inadequate information that then puts the police officer in the database when maybe they shouldn't be in there. So as I said, and as Larry said, this has been going on for some time. And we have tried repeatedly to convince the police department that it is a broken way of doing things. Unfortunately, the police department has said, no, we are making the call and we're going to decide what information we give you and essentially how we give it to you and when we give it to you. And as a result of that, after many, many attempts, we finally decided we cannot continue jeopardizing convictions based on our inability to get information that we are entitled to. So certainly it was a last resort. The idea that a prosecutor has to subpoena information from their partner in prosecution, the police department, may seem a little unorthodox, but we were forced to do it. So essentially, the motions that are before you today are based on us saying, if you're not going to agree to be our partner and give us information that we are legally responsible for, then we are going to subpoena it. And I think everybody knows a subpoena is tantamount to a court order. So essentially we said, we are going to court order you to turn over the information that we are entitled to have, review, and disclose where appropriate. So these subpoenas were done, and they were done in thousands of cases, because another thing the police department has insisted on is that they will not only decide what we get, but they say we only get it when we ask for it in a pending criminal case with an upcoming court date where a particular officer is a potential witness. So what we did is we looked at upcoming court dates involving various different officers, and we put together over 4,000 subpoenas where we specifically subpoenaed the police department, the custodian of records, saying, you have to give us all of the information that is responsive to our request. After we served the subpoenas properly on the police department, we really didn't hear anything. I think there was an acknowledgement that they got it. And then approximately 2 weeks later, what they did is they gave us the same stuff that they'd been giving us without the subpoena. They didn't complain. They didn't say the subpoena was in any way improper or not filed pursuant to the law. Instead, once again, they just unilaterally made the legal decision as to what we really are entitled to and what should be disclosed. So as we got their responses, which more often than not were inadequate, and inadequate means not sufficient information. Sometimes it was information that was just absolutely incorrect. For example, sometimes they would tell us, we have nothing that fits the category or qualification of misconduct information for a particular officer, when we knew in fact they did, because they had told us previously that they did. So we went through all of these responses and we said, what next? What next if the police department, our partner in prosecution, is not going to honor essentially a court order saying, give us the information? So logically, what we concluded was, what is next is we've got to continue to ask for judicial intervention, and specifically ask that the police department at least be forced to respond to why they think what they're doing is appropriate. But on the opposite end of the spectrum, hold them in contempt. Any other citizen in our country, if they were properly served with a subpoena and they didn't respond and they didn't legally do what you should do if you've got a problem with the subpoena, could be held in contempt and, quite frankly, could be put in jail. And so what we're doing is we're saying, look, they should be held in contempt, but what we want is compliance. We're not saying we want anybody in the police department to be put in jail, but we want them to be forced to comply. And that means that they have to give us the appropriate information pursuant to our request, and they need to do it in such a way that we are able to live up to our constitutional obligations. And we are hopeful, by putting all of this out in the motions that we have filed, that the police department's going to see the light. And as Larry said, good conversation with the police commissioner. We have hopes that she wants to do the right thing. And we also have hopes that a lot of this attitude that we have kind of predates the police commissioner, and she doesn't really absolutely understand the depths of the problems that we've been experiencing, but she certainly is interested in learning. So our hope is that this will make everybody come to the table and figure out how to get it right and move forward. So as Larry said, not only are we making sure that we're not compromising cases and convictions, but we're also making sure that everything that we are doing is with integrity. And at the end of the day, that means that as our partner is the police department, we will work together to do the right thing.
All right, those are some details. I could make some more comments, but why don't we just go to questions? Are we receiving questions by email or how's that happening?
That's done.
All right, so my understanding is Dustin Slaughter from the DA's office is facilitating receiving any questions from media, and we're happy to answer them. Are we in the chat? All right, the chat is full of discussion of our failed microphone from earlier. I think maybe a software update is in order. Question from Mr. Bender. Can you explain the 6 cases? And I'll turn that over to Ms. Cummings.
So what I'm going to say is I recommend that you look at the motions, because what we've done in each of the motions is we've given a little factual background for the case and who the officer is. And what I want to be careful of course, that's important, because what we're saying is the failure to get adequate and accurate information about that officer could put us in a position that compromises the prosecution and maybe an ultimate conviction in the case. We want to make sure you don't get lost in the weeds of that, because really what we want to do is we want a judge to look at this and not just say, I'm looking at that particular case and the facts of the case and the officer involved, but I'm looking at the big picture. And I'm looking at how we have had over 3 years of the police department not responding appropriately to our request. And so it's a small portion of each motion, but it's there if you want to know more facts. But as I said, I think the big picture is what we're trying to get folks to pay attention to.
So I see Mr. McDonald has a question. Is this suit in city or federal court? I think I can answer that. This is not a lawsuit. This is actually a motion that is being filed in criminal court, in the Court of Common Pleas, and also in municipal court in Philadelphia County. So this is being filed in criminal matters that are currently underway in municipal court and CP court in Philadelphia. And as an aspect of those criminal matters before they get to trial, we have filed a motion with these various judges seeking to put it all in front of one judge, in which we are saying that we need this information in order to continue on with the case. Are there any other questions? From Mr. Bender, have you been in any discussion in the Kennedy administration? Yes, I have spoken personally to our police commissioner, who has, a hotline to the mayor, and the mayor is not terribly accessible these days. And, we are speaking to the entity that is most directly involved and most knowledgeable about their own paperwork. I would be delighted to have a phone call from Mayor Kenny right now, if he would like to do so. But I mean, the truth is, this is really a discussion that begins properly between the police department and the DA's office. All right, and we have a question for Philip Hendricks. This feels pretty general. Some details would be helpful. I'm going to suggest that Ms. Cummings might give some specific examples. My understanding of the situation, and I was involved with reading some of the drafts here, my understanding is that we know that this is not just a theoretical issue, because even though the police did not give us what we needed, we found a few cases where, separate and apart from this, the Defender Association, by its own subpoena going a different route, actually got the material. So we are able to take what was either not provided or what was blacked out to us, and then compare it to the documents themselves. And we are able to determine from that how important this information was, instances where it clearly should have been turned over, and frankly, some action on the part of the PPD to make sure we couldn't read the stuff. But I will let Ms. Cummings respond.
Yeah, I can add a little bit. So one of the cases in particular involves a police officer that is actually the complaining witness. So the police officer is the victim in a case. And so it's kind of like what I would call a double whammy, right? Because you've got an officer, obviously, whose credibility in any case is going to be important. But in this case, you've got an officer who is the victim. And so credibility could certainly weigh on whether or not that person had a criminal offense committed against them. So we looked at that case and we did not get an appropriate response from the police department in regard to misconduct that that officer had engaged in. And so we laid that out in the motion and we said, here's an example of why it is so important that we get this information so that we can consider it as prosecutors and try to decide how it impacts the way we look at the case. But even more importantly, to speak once again to our constitutional obligation, we've got to make sure that we're turning that information over to the defense. There's a couple of other questions, Larry, and I was going to just jump into those.
Well, let me do this one, but I would like to ask you, Patricia, if you would, could you just give some concrete examples of situations in which we weren't given information, but we found out what we were not given and how it mattered?
Right, and so that's happened a couple of different ways. One is we were not given information because the police department not only have they unilaterally decide how they're going to respond to us, but they've even created their own forms for how they give us information. And so in a lot of instances, they would give us a form saying, and I mentioned this a little while ago, saying that we have nothing responsive to your request about this particular officer. And kind of the craziness is that we have been doing requests at the police department for the last 3 years, and we had gotten previous responses from the police department about that particular officer where they actually said they did have something. And not only did they have something with a prior request, that something was so significant that it involved an officer getting in trouble for lying. But then in response to the subpoena, they say they don't have anything. And so that is, in my mind, a really good example of recognizing how deficient their responses have been to our subpoenas. Now, I said there were 2 examples. That was a way that we can internally check with whether or not we were getting proper responses. But Larry has talked a little bit about how we did an external check to see whether or not we were getting information that we are entitled to, and quite frankly, that we are presumed to have. And that external check was us knowing that the prior administrations had never disclosed in any uniform way this information to the defense. And so we knew that what the defense did, and quite frankly, the defender, I think, did a pretty good job for decades, is they would subpoena the information. And once they subpoenaed the information, more often than not, the city, on behalf of the police department, would produce the records that existed that were responsive to the defender's subpoena. So knowing that, what we did is we did kind of a checks and balance. We looked at particular responses involving officers, and then we turned around and we issued a subpoena to the defenders asking for any of the records they had regarding those police officers. And in response to the subpoena, they responded like they're legally supposed to. They gave us the internal affairs documents that they have. And quite amazingly, what we learned is that oftentimes when the defenders subpoenaed the information, they would end up getting what appears to be the entire internal affairs investigative file, which oftentimes is at least 20 times more information than we would get if in fact the police department said there was something responsive to our request. But they were also getting the information in largely unredacted form. So the police department, when they came up with this unilateral policy of what they would get us and in what form, how they redacted it, they told us we have to redact it because we have to protect the safety of witnesses and victims. Yet what we discovered is, despite them saying that that's what they're trying to do in the redactions, they have been historically turning over information to the defenders that is not redacting out that information. And in some instances, and you can see this in the motion, what we found was, in addition to just getting so much more information, they were getting all kinds of facts about officers lying. And the information we had gotten didn't show that. And obviously, as Larry and I have said repeatedly, an officer that gets in trouble for lying goes to the very core of what it means to be credible or not credible in regard to the criminal prosecution of an individual where you're trying to take away their liberty.
Yeah, let me just add to that a little bit, because I was with some frequency during my 30 years before I became DA, I was with some frequency the guy in court saying, yo, judge, I have subpoenaed the records on Officer X. Let's just say Officer X was one of the 6 indicted and taken to a trial down in federal court a few years ago. Can I have the stuff? And what would happen then is you would have an assistant city solicitor coming in. So a lawyer would be coming in. Often they would try to stop the defense attorney from obtaining the information, but ultimately, between having a lawyer from the city solicitor's office there and having a judge, there were occasions when you would get the information. It was not, however, at a time when there were 70,000 cases, it was not systemic. It was not system-wide. It relied on a pretty diligent defense attorney to fight hard and do extra work to get that kind of information every now and then. The difference between that and this is that the police are supposed to give it to us straight up. No judge involved, no city solicitor standing in the middle saying, hey, you got to do this. They're supposed to give it to us, and they're supposed to give it to us systemically. There is a question here I'd like to touch on, which is, has the union played a role in creating the situation? I think it's very important we understand what the union means. Has the leadership of the union? You bet. The leadership of the union has been hell-bent on preventing access to constitutionally required information time immemorial. John McNesby lives in Frank Rizzo's shadow, and he always has. Even though that statue is gone, he still imagines a shadow. And so the mentality is one that is unguided by law, has little to do with the Constitution. The mentality is circle the wagons and protect our own at all costs. Of course, what our own really means in that context is not the good and honorable Philadelphia police officers who are required to be members of that union, the vast majority of whom don't have a bad record, don't engage in serial bad conduct. Those officers are injured by what the police department is doing here, because those officers would like us to see that they have nothing, or they would like us to see that what they have is not serious and does not need to be turned over. We're not able to help those officers. The only people who are being helped, because juries are not being helped, judges are not being helped, prosecutors are not being helped, the system is not being helped, the public's not being helped. The only people being helped by the system are a small number of dirty cops. Those are the only ones being helped. And as best I can tell, that is all the leadership of the FOP actually cares about. It's a fundamental problem. We have leadership of what could be a great union that has gone rogue. And this is just one more example of how we have to try to change culture and correct culture. Yes, our police commissioner is up against a big shift. She's up against a lot of difficulty in trying to change this culture in the same way that we are having challenges in trying to change the culture of the DA's office after decades of it going in what was almost an opposite direction. And I'm not kidding when I say that. We could get into that if you have more questions about it. So I think that that's a very important question. Patricia, if you want to add on to that, that's fine. But I would also give you the next question, which is from Dan Slepian, and that is, if a judge agrees with you, is there an individual held responsible in the Philadelphia Police Department?
So I just kind of have to hearken, Dan, back on what I said a minute ago, and that is, we really are not looking to punish the police department. What we desperately want is compliance. And so that's what we're asking for. And so specifically in the motions, what we've said is we'd like a judge, and ideally what we'd like is one judge who looks at this, because as Larry has said, it's a systemic problem that affects us as prosecutors in all of our cases. So we want one judge to look at it, and for a judge to say that we're right and that the police department was legally wrong and in violation of a court order. And then what we want is we want some period of time where a judge is going to monitor the compliance and make sure that the police department understands that this is an obligation they have to us that should go on forever. Because I can't imagine a world where we're ever going to say that a fair trial in our country does not require that we abide by these rules and turn this kind of information over.
So let me just, I don't know if there are any more questions. We welcome additional questions. We're happy to talk for quite some time, honestly, about this because it's an important issue. But let me just say something that I think often gets lost in the mix. It is very, very clear that there has been a breakdown between law enforcement, and by that I mean prosecutors plus police, and the community, and that this is one of the major impediments we have, both in investigating important cases such as shooting cases, where witnesses will not come forward, but also in obtaining convictions from juries who are often rightly skeptical that they're being given the whole truth. And they're rightly skeptical because of the kinds of things that happened to Anthony Wright and Walter Ogrod and Chester Holman and all of these other innocent people who have been released after doing decades in jail when law enforcement, and by that I mean prosecutors and police, did not turn over information that was necessary to turn over. Now, what is the effect of having a prosecutor's office that says, we're not doing this anymore? We are actually going to provide all of the truth, and then we're going to do our job vigorously. What is the effect? Well, I suggest to you the effect is it increases trust. It increases trust in ways that make it more likely that witnesses will come forward in a shooting, that they will be willing to come to police or the prosecutor's office or both and say, hey, I saw this and I'm not afraid of you like I might have been 10 years ago, because I'm not afraid you're going to put it on me. I think you're trying to be fair. And when you're trying to be fair, I will participate. There's that, but there's also the other aspect of it. You know, we have a very high rate of conviction for gun violence cases right up until the point where the courts mostly shut down due to the pandemic. And there's a reason for that. And part of the reason, I think, is best exemplified in a little anecdote that I heard, which is, I won't name this person, but there's an attorney in this office who philosophically is not necessarily completely progressive. God bless that attorney, a hard worker who's been here for quite some time, who has been known to get up and make the argument to judges and juries that, we're giving you a case beyond a reasonable doubt because you can actually trust this office. That is important. When you get to the point where judges and juries have a real factual basis to believe that prosecutors are trying to be fair, they are actually more likely to convict, more likely to believe what they are hearing. And that is what we are trying to accomplish here. We are trying to do our duty, and I have a sworn oath to uphold the Constitution. We are trying to seek justice, and I have a sworn oath to do that. But we are also trying, as an aspect of that, to restore trust in ways that increase the participation of the community in keeping themselves safe and protected. I see we have another question. And this is from Claudia Lauer at AP. And this gets into the weeds a little, but when you request this information, there are certain disciplinary actions that are wiped after 5 years or 2 years, depending on the violations. When you or the defenders request this information, do you run into issues with those negotiated policies regarding discipline? Or are these the kinds of offenses or issues that would stay on record for career duration? Patricia, do you want to address that?
Yeah, we've actually, first let me say that's a really good question. We've talked to the police department quite a bit about that. And I think the public is probably more aware of those issues than ever before with what we've seen going on in the last year and a half. But unfortunately, I think we all know that the disciplinary system, I'm going to say, of the Philadelphia Police Department and other police entities across the country is pretty broken, because oftentimes what happens is that there is an investigation that concludes that an officer did indeed engage in a certain type of misconduct, but then through the arbitration process, it eventually either goes away, is ordered expunged, or it gets downgraded, and ultimately an officer is allowed to go back to his normal duties. So we have talked about that, because regardless of how broken the system is, that does not change our obligation as prosecutors. What we are looking at is what we call the quantum, or the amount of evidence that establishes that the misconduct occurred. And so you may have the police department later on, based on some technicality, saying, I'm going to erase that from the police officer's record. That doesn't change our obligation to turn the information over. So if they would comply with what we're doing, we are not going to run into these problems, because if they're giving us the information as it occurs, we then look at that information, and if in fact it qualifies as something we're obligated to turn over, we're going to turn it over. And so then later, if it's a year later or 2 years later, the arbitration process, no matter how broken it is, says, oh, we're going to let this police officer wipe that from their record. They got to understand they're not wiping it from our records. You can't just wipe away favorable information and information that goes to the heart of the credibility of an officer. So this is why it's so important that we get compliance and we get the police department to understand when they get that information, they've got an obligation to turn it over to us. And I think that it addresses your question.
Are there any other questions? All right, question from Kristen Johansson. As you have mentioned, you spoke with the commissioner. What resolution did you both come up with moving forward? I had a conversation with the commissioner in which I explained to her this motion. There have been ongoing conversations with high-level brass at the PPD, but also the commissioner at various different times during Richard Ross's term, but also during Police Commissioner Outlaw's term about many of these issues. So these talks go back quite a ways, but most recently I spoke to her just yesterday. I explained to her the motion. I talked about the necessity of our filing at this time in order to make sure we satisfy our legal obligations, and left with what I understood to be a willingness and a commitment to further this conversation. I felt pretty hopeful based upon that conversation. I look forward to speaking with her at her first opportunity, and having the most involved brass at the PPD and some people from the DA's office sitting down at a table. We don't have that set yet. I look forward to hearing from her when she's available. And hey, man, I'll meet anytime. All right. There being no further questions. Oh, here we go. All right. If there are no other questions, then thank you for your time and interest. A recording of this briefing will be available on the DAO's YouTube channel. Feel free to email Dustin.Slaughter, SLAUGHTER, at phila.gov to request the link, or you can visit the link that is left in the chat, which is essentially youtube.com/Philadelphia District Attorney's Office. Thank you all very much.